Welcome to our training on considerations for petitioning in the care process. So today's training will cover eligibility criteria and court referrals into care with a focus on areas relevant to the petition process. But most of our time will be spent talking about considerations and strategies with regards to the petition process and care. So this training is specifically targeted for county BH agencies. That said, this content may be helpful for courts and counsel, family and peer organizations, volunteer supporters, and other stakeholder groups involved in care. We do have specific resources for those family members who are interested in the petition process. So if you're a family member and you would like more information about filing a petition, there are some great resources available to you through self-help centers. And we include a link to self-help center locator in our materials. We also have a training on the family's role in the care process, which will help have you give you additional context. So that training is available on our website, and again, linked in the materials for this training. And we want to thank our counties, Glenn, Tuolumne, Orange, San Diego, and Los Angeles for contributing thoughts about the petition process that we've included here, including some problem-solving strategies that they've implemented to overcome some challenges that have arisen in the petition process. So we're grateful for them for sharing their lessons learned as they've begun to implement care. As we jump in, I wanted to cover some our agenda for today. So we will be, like I said, revisiting that eligibility criteria, and you can view our training materials on the eligibility on our website as well. The second section will focus on the petition filing process. We'll discuss eligible petitioners, go over the who, what, and where of filing, and also discuss practical, cultural, and accessibility considerations for petitions, focusing on some of those problem-solving approaches that have been effective in counties. So let's look at our learning objectives for today. The goal is that by the end of the session, you'll have an increased ability to understand the eligibility criteria in the petition process, identify potential pathways to access care, understand the petition filing process, and identify and address practical considerations related to petitioning. Want to introduce our speakers today. We're pleased to be joined by Dr. Deborah Rose, an associate principal with Health Management Associates, who is a licensed clinical psychologist with a history of designing and scaling initiatives and behavioral health services, and also Leela Kapoor, who is a contractor with HMA and has more than 30 years of public service as an attorney representing Los Angeles County and the city of Los Angeles, and has experience as a counsel for the county's Department of Health and Mental Health. So with that introduction, I wanted to turn it over to the presenters to jump into eligibility and then walk us through the petition process.
Thanks, Patricia. It's great to be here today with you and Leela. I'm excited to present and talk about some of the material that we've developed. As we often do, we like to begin with an example of a person who you may encounter in the care process. This is not a real person. It's somebody that's based on our experience of having worked with individuals similar to those that you work with and that the individuals that you may encounter. We're going to refer to this example as Jason. Jason is a young adult, 29 years old. He's from Sacramento. His family is in Sacramento, but he spends a lot of time in Fresno. He moves about a bit. He graduated high school, attended college, and had his first psychotic episode, his first break, in his freshman year of college. Since then, he hasn't been doing so well. He's been hearing voices. He's been living on the streets. Looks like he's experiencing some auditory hallucinations. Again, those voices that other people don't hear, some paranoid thinking. He's been surviving by eating out of trash cans and bins. He has had multiple hospitalizations, and it's during those hospitalizations that he has some contact with his family, in particular his father, George. As a result of the way that he is living on the streets, he's had a number of encounters with homeless outreach workers and first responders, and it's during those times that they get to know Jason a little bit better. It's important to note that Jason also has a vision impairment, and as a result of his lack of self-care and his inability to get medical care, his vision is rapidly deteriorating. So let's keep Jason in mind as we go through this training. We'll refer back to him a few times. So a quick refresher on care eligibility. Care is designed for adults 18 and over, individuals who are experiencing a severe mental disorder, specifically schizophrenia or other psychotic disorders along the schizophrenia spectrum. It's designed for individuals who haven't been clinically stabilized in voluntary treatment. It's the least restrictive alternative to other interventions, and it's designed for folks who are likely to benefit from services. It's also important to note that one of the following two conditions are eligibility criteria. The person is unlikely to survive safely in the community without supervision, or the person is in need of services and supports to prevent relapse and deterioration. And so when we think about Jason, who is living on the streets, eating out of bins and trash cans, who's not caring for himself, who appears to be hearing voices, let's think about if Jason may meet the eligibility criteria. Let's go to the next slide, please. Important to note as we talk about eligibility that ultimately it is the judge who makes the determination if a petition shows that the individual meets or may meet criteria. So let's talk a bit about what we know about Jason and the questions that we would ask ourselves in the petition process. Are his symptoms severe and persistent? Well, it appears that Jason is responding to internal stimuli. He seems to hear voices that other people don't hear. He is interacting with the radio. It looks as if Jason thinks that the radio is talking to him directly or about him as a result of some of his behaviors. As I've mentioned, first responders have been called in a number of times. Do his symptoms interfere with his daily life? Clearly they do. He's living on the street. He's not well nourished. He's not tending to his vision or his other medical needs. Is he involved in outpatient services? At this point, it appears that he's not, although we don't know based on the scenario that we're considering. Will care be the least restrictive environment? Certainly, it is less restrictive than other kinds of interventions that could be provided. So care appears to be the least restrictive based on the kinds of services and supports that can be offered. Is he unlikely to survive safely and independently in the community without supervision? Is his condition deteriorating? Well, it seems that he's experiencing more intense and more frequent hallucinations and delusions. As a result of his paranoid delusions, he has very little contact with family. He only talks to his parents, George and his mother, when he is in the hospital. And again, his vision is deteriorating. So it does seem that care would be an appropriate option for Jason. One question that remains open, and we have intentionally left this open, is what's his diagnosis? We recognize that often petitioners may not be aware of the diagnosis that an individual carries. And so we want to walk through that process together with you. Let's move on to the next slide, please. So as we continue this training, I would encourage you to consider what are some scenarios that you might not know an individual's diagnosis. Certainly, we know that people often takes a little while to reach a final diagnosis. Somebody may carry more than one diagnosis as a behavioral health diagnosis is ruled out. And so I would encourage you to think about, maybe jot down what are some scenarios that an eligibility criteria may not be clear. I do want to reinforce, and you'll hear it again throughout this presentation, that even if Jason in this situation or another individual does not meet eligibility criteria, that the judge has not determined that those conditions are set, that outreach and engagement and services should continue to be offered and provided to the individual. I'm going to pass it over to my colleague, Leela.
Thank you, Deborah. Now that we have discussed whether Jason meets or may meet the eligibility requirement, let's just spend a few minutes revisiting the care process. You may have seen this chart or a version of this chart before. This particular flow chart was adapted from Los Angeles County's CARE Act process map. So we thank them very much for their contribution to our material. Today's discussion will focus on the initial stage of the process. So the left-hand side of the chart, specifically the care process initiation and the engagement phases of that process. Throughout this training, keep in mind that the purpose of the petition is to initiate the care process. And the first thing that happens with every petition that is filed is that it is reviewed by a judge. It's reviewed on its face, so the judge will look at the petition and its contents, and they will determine whether the petition presents sufficient support that Jason meets or may meet the eligibility requirement. This is, a fancy term for this is prima facie, but it basically means that the judge will look at the document on its face to determine whether it provides enough information to support a conclusion that the individual meets or may meet the eligibility requirement. Because the judge needs to make that determination, it is extremely important that the petitioner include as much information as they can to provide the judge as much information as possible to make his or her determination. If it is found that Jason meets or may meet the eligibility criteria for non-behavioral health agency petitions, so for example, for petitions filed by a family member, the court would order county behavioral health to reach out to Jason. And that outreach is for two purposes. It's to attempt to engage Jason in voluntary services, and it's to provide an opportunity for behavioral health to assess Jason and provide information to the court with information as to whether they believe Jason meets the criteria. As shown on the chart, if voluntary engagement is successful, then the petition would be dismissed and Jason would participate in services and supports voluntarily. If voluntary engagement is not successful and the judge has determined that the petition meets the prima facie review, the case would proceed through the care process. Early in the process, the non-behavioral health agency petitioner, so in our example, a family member, would be replaced by the county behavioral health agency. And that happens at the initial appearance on the petition. So it happens very early on that the behavioral health agency becomes the petitioner in all care cases. Extremely important to remember that ultimately it is the court, with behavioral health professionals' input and the input from others, including the respondent, to determine whether or not the respondent is eligible for care. So let's move on to the next slide and talk about the who, what, and where of petitions and talk through some practical considerations that you should keep in mind if you are considering filing a petition in care. So let's talk about who can file a petition. You may be familiar with this list. This list is broad, and therefore it is possible that more than one person may be eligible to file a petition for Jason. You should note that in many instances, the eligible petitioners include a designee, indicated by an asterisk on the slide. Therefore, for instance, the director of the county behavioral health agency does not have to file the petition personally. They can appoint somebody or designate somebody to file the petition for them. So when thinking about filing a petition, consider who is in the best position to file a petition and if there's a way to collaborate to reach that goal. Next slide. So let's talk a little bit about what the counties who have already implemented CARE have seen as far as the petitions filed in their county. What they're telling us is that many of the petitions are being filed by family members. They're seeing petitions filed by the county behavioral health agency upon referral from the LPS or the conservatorship court. And we'll talk about the relationship between CARE and conservatorship courts a little bit later on in the presentation. They're seeing petitions filed by county behavioral health upon referral from a first responder. And they're seeing petitions filed by respondents themselves. They're filing petitions on their own behalf. Primarily, these individuals are persons in custody. And presumably, they're filing these petitions with the assistance of counsel. so as to create a pathway to services once they are released from custody. Notably, what we're not seeing are petitions being filed by hospital settings, and that was something that was expected but has not yet happened. We have also heard from counties that collaboration between the County Behavioral Health Agency, law enforcement, first responders, county social service agencies, and private providers is a very effective way to make decisions around the petition filing process, as well as proving very effective in all stages of the care process. So one of the things that you're going to hear later on about is collaboration and how important it is for collaboration, again, among the county agencies, as well as with family members.
Since this training was originally recorded, the petition forms produced by the Judicial Council of California have been updated as of July 1st, 2025. So we wanted to just go over some of those changes and provide some general guidance about completing the petition. So the purpose of the petition, remember, is not to prove everything up front, but to give the judge enough information to decide whether the case should move forward. Based on what's submitted, the judge may either dismiss the petition or ask the County Behavioral Health Agency to investigate further. The petition doesn't need to be exhaustive. It should include what you know and have observed and enough to reasonably believe the person may meet the care criteria. So there are two different ways to file a petition depending on who you are and what information you have. Regardless of which option makes sense for you, the petition will ask for information about the petitioner, information about the respondent, such as how to contact them and any language or accessibility accommodation that may be useful, and information about a court referral, if applicable. The bulk of these forms will focus on capturing information related to an individual's potential eligibility. So let's talk about these two options. So the first option that you see on the top is a general petition process that would make sense for most petitioners. You would use this path if you're not a licensed behavioral health professional, for example, family members or first responders. Step 1 would be to fill out the Care 100 form, which lets you explain your observations in your own words. And step 2 would be including one of the following to support that petition. So the Care 101 form. So this would be a declaration from a licensed behavioral health professional who's either examined the individual in the last 60 days or has tried multiple times. And they must believe the person may meet the care eligibility criteria. So the other option to accompany the Care 100 form is documentation. So this would be evidence that the person has had at least 2 intensive treatment, one within the last 60 days. So this could include hospital discharge papers or a signed declaration for someone with direct knowledge of those hospitalizations. So if the person completing the petition, the Care 100 form, has direct knowledge, the declaration of the 250/250s can be included directly on the Care 100 form. Otherwise, that information can be attached to the petition, like I mentioned, a hospital discharge paperwork, a declaration from a witness, or other evidence of those 250/250s. So that's option 1. Option 2 is a streamlined process for licensed behavioral health professionals. So you would use this path if you are a licensed behavioral health professional, which can include members from County Behavioral Health Agency. So for this option, you would only fill out the Care 102 form. This combines both the petition and the declaration from the licensed behavioral health professional into one document. Like the Care 100 and the Care 101, this Care 102 form allows you to describe what you've observed and why you believe the person may be eligible for care. Regardless of which option you use, the key is to provide enough detail for the judge to decide whether the case should proceed, not to prove everything. If the judge believes there's a reasonable basis, they may request more information or begin the formal care process. Just document what you know and keep the focus on what you've personally seen or learned. For more information about the mandatory forms, you can see the forms on the Judicial Council website, and there's many resources on the CARE Act resources for petitioners page, including additional tutorials and information for different petitioning groups.
Let's talk a little bit about access to protected health information, or PHI. PHI is designed to ensure that individuals have privacy and that their medical and behavioral health notes and information are kept confidential. We recognize that a practical consideration for non-behavioral health providers who may become petitioners, people like family members, like George, Jason's father, first responders, outreach workers, might not have protected health information, might not have Jason's medical or behavioral health diagnoses. And so Leela talked about collaboration, and I think that this is an opportunity to recognize that people without access to PHI might benefit from connecting to those who have it. So certainly for family members, we recommend connecting with the County Behavioral Health Agency. It's important to note that family members can always provide information. They can give information to the courts, they can give information to the county agency or to behavioral health providers, although they might not be able to receive that information in turn. So when thinking about a petition, again, we encourage the collaboration, particularly the family members, with the behavioral health agency, with other professionals who might have worked with the individual, prior treatment and recovery professionals. Certainly family members are encouraged to gather available information, to document that information. Again, it's up to the judge to determine if the individual meets criteria for care, and we are hearing that judges are listening very closely to the family members who are providing written documentation about their knowledge of prior hospitalizations, prior 5150s, interactions with behavioral health providers. So again, it's really essential to gather that information and to document it in the form of an affidavit. We also understand that SB 35 has addressed sharing of information with the court and with the County Behavioral Health Agency. It's important to note that that doesn't compel behavioral health providers to bring forth their petition or to share information. But again, family members who are involved can always share their knowledge of services with the courts and with behavioral health providers. Let's go to the next slide, please. So when thinking about a petition, Leela has talked about this long list of people who may be eligible petitioners, agencies, organizations, individuals. It's really important, again, to consider collaboration. Who's the best person to bring forth a petition? And so when you consider determining who that individual or who that organization may be, there's a couple things to consider. We've talked about George, the father who has had some contact with his son while he's in the hospital. That may be an opportunity to document the dates of hospitalizations, the locations, what kinds of services were received. First responders, we've talked about outreach workers, homeless outreach workers, and first responders interacting with the individual. Might have difficulty obtaining diagnoses, but certainly can provide supportive information. They may work with the behavioral health agency. And then we recognize that, again, people are petitioning on their own behalf. Leela has mentioned that we're hearing about individuals who are in carceral settings bringing forth petitions with the help of an attorney. They may be able to provide really relevant information leading to the CARE petition. Leela, I'm wondering if you could talk a little bit about geography.
Sure. Thank you very much, Deborah. So we talked about the who and the what of a petition. Let's spend just a couple of minutes discussing where a petition can be filed. By law, you can file a petition in one of three places. You can file a petition where the respondent resides, so their county of residence. You can file a petition where the respondent is found, so where he is located, or you can file a petition in a county where the respondent has a court proceeding, whether it be a civil or a criminal court proceeding. So in many cases, such as with Jason, there may be more than one county which would be appropriate to file a petition. So what do you think about when you're trying to determine where to file the petition? You may want to consider where the respondent is most likely to be located. Obviously, locating the respondent for purposes of engagement and participation in the process is critical. You may want to think about where the respondent most likely will have access to the services that they need. Where does the respondent have the strongest support system? Where has the respondent had prior contact with behavioral health services? Or where does the respondent have a sense of inclusion and acceptance in the community? All of these considerations are aimed at determining the county in which the respondent is most likely to successfully participate in the care process. So let's think about Jason for a second. Jason's county of residency is Sacramento. He was located and apparently spends a significant amount of time in Fresno. So one of the questions you may ask is, has he expressed a preference? Has he expressed that he prefers Fresno over Sacramento? You may want to consider where he was most recently treated. Was he successful in any way in that treatment? Does he have a connection with a behavioral health provider or peer support specialist in a particular area? Has he utilized shelters or housing resources in a particular area? Or has he ever mentioned family or friends or other supports in a particular area? Again, with the goal of determining where he is most likely to be successful in a treatment plan. So moving to the next slide, the CARE Act establishes three referral pathways that can lead to the petition being filed. So we discussed petitions being filed by eligible petitioners. Pursuant to the CARE Act, there are 3 court referral processes that can initiate the CARE proceedings. The first is the misdemeanor and incompetent to stand trial. The acronym is MIST. And in that instance, the court can refer the individual to CARE. The court makes the referral, but the county behavioral health agency files the petition. If the individual is accepted into CARE, the charges are dismissed. The second referral is assisted outpatient treatment. Again, the referral is made by the court, and the county behavioral health agency is the petitioner. And the third is the LPS conservatorship. So in that instance, the referral is made by the court, and the conservator or the proposed conservator is the petitioner. Let's talk a little bit about the relationship between the conservatorship, court, and CARE. There is a misconception that the CARE Act provides a referral from CARE to LPS. This is not true. The CARE Act allows for a referral from LPS to CARE, but not the other way around. However, what the CARE Act does do is it provides that if a respondent fails to successfully complete their CARE plan, and it's a CARE plan, not a CARE agreement, and all the services and supports have been offered to them, so they had an opportunity to complete the plan, but for some reason they did not. The fact that the respondent failed to successfully complete their plan shall be considered by the court in a subsequent LPS hearing if that hearing is held within the next 6 months. So if that hearing is initiated within the next 6 months, the failure to complete the CARE plan would create a presumption that the respondent requires additional intervention beyond the CARE Act. It is important to note that this does not apply to a respondent's failure to comply with a medication order. So if the respondent's only failure under their CARE plan was failure to comply with a medication order, this provision is not triggered. The CARE Act process is an alternative to LPS that every public guardian and conservator should consider when evaluating the best option for an individual. Next slide. There are numerous resources out there to assist a petitioner in filing a petition and considering whether a petition should be filed. We mentioned briefly before the self-help centers. The self-help centers are sponsored by the Judicial Branch of California. There's a self-help center locator that you can use to identify the self-help center most accessible to you. The self-help center staff are trained on the CARE Act, and they're there to provide guidance on determining whether you should file a petition and how you complete the form. Cal HHS has put out an information for CARE Act petitioners webpage, which has numerous resources on it. the judicial branch has produced the CARE 100 form, which is a 2-page primer on filling out the petition. And NAMI's CARE Act webpage has videos and other information for petitioners. We understand in the coming months, they will be putting out additional training videos on their webpage. So those are all excellent resources to assist you if you are looking into filing a petition. Next slide. One of the questions that we hear a lot is, what is my role after I file the petition? And this is as to family members or non-county BH petitioners. Let's talk about family members in their ongoing role. As we discussed before, once a petition is filed by a family member, very early on in the process, the behavioral health agency is replaced in as the petitioner. The original petitioner, the family member, can be present and may make a statement at the initial hearing. After that point, however, their participation is limited. The court may assign ongoing rights of notice to the original petitioner. That's at the court's discretion. And what that means is the petitioner may receive notice of future hearings. That does not mean that the petitioner would be allowed to participate in those proceedings, but it would give them an opportunity to at least track the progress of the care proceedings. If the respondent consents, the court may allow the original petitioner to participate in the respondent's care proceedings. Again, this is up to the respondent. Respondent has to consent to that participation, and the respondent can dictate the extent of participation. And finally, the respondent may select the original petitioner as their volunteer supporter. What this means, again, is at the respondent's discretion, and if they select their family member to serve as their volunteer supporter, that individual can continue to participate in the process to the extent that the respondent would like them to. Next slide. Let's talk for a minute about strategies for serving the petition. It is the behavioral health agency's responsibility to serve the petition, but you need to keep in mind that serving the petition may be their first contact with the respondent, so it needs to be approached thoughtfully. What we've heard from the counties who have already implemented the CARE Act is that they have discussed different strategies and different sequencing on how to best serve the petition. We're hearing that some counties are employing what they're calling rapid serve, which means that they are both serving the petition and engaging the respondent at the same time. They believe that because they have the right people there, they have the right team of individuals present, and they've located the respondent, they want to use that opportunity both to engage the individual and serve the petition. Other counties have determined that they would prefer to engage the respondent first and then serve later so as to establish a relationship before providing them with the legal documents. We've heard that the teams are composed differently. County behavioral health staff is often included, outreach workers, sometimes peer supporters, respondents' attorneys if they've been appointed already, and then law enforcement. Would stress that we've heard that if law enforcement is to be present, they would prefer that they were in plain clothes as opposed to uniformed. Many of the counties have stressed that they found it helpful to have a peer present when serving the client. Let's move to the next slide. Deborah, do you want to speak a little bit about the cultural and accessibility considerations when filing a petition?
Yeah, thank you, Leila. So let's talk about those items. And I think it's important to note here that the slide talks about accessibility and cultural considerations with family members, but it applies to the individual, the respondent as well. So a few comments to consider is providing petition forms, information, education in multiple languages, in a language of an individual's preference. Some folks might benefit from adaptive technology and certainly account for all of the reading levels of the people that you're working with. In Jason's case, he has a vision impairment, and we might consider large print or braille if it was requested in forms and other information. Some individuals might benefit or request interpretation services, and whether that's done remotely or in person. We mentioned remote, and certainly use of that kind of technology may be preferred and more convenient for some people working with the courts and the behavioral health agencies. In some cases, individuals may not be as comfortable with technology and would benefit from having somebody to assist them in that process. A few other ideas are services outside of traditional hours, perhaps evenings, weekends, and then certainly offering and embracing a trauma-informed approach when working with petitioners and with individuals. It's a difficult process for family members, and it's just important to ensure that behavioral health agencies and that courts are providing these kinds of supports in a culturally responsive manner. We have offered trainings previously on cultural humility and trauma-informed care, and so we refer you back to those for more education. Let's go to the next slide, please. We like to talk through some of the things that we've learned. We've talked about who may be an eligible petitioner. We've talked about some of the required information. We've discussed assistance that people can receive, the petitioner's role after the petition is filed. So let's think about what this might be like using Jason, our example. And in this case, let's talk about the who. Leela, we talked through maybe several petitioners who might be identified for Jason. First responders, family members, a hospital, a behavioral health provider. Can we maybe give some additional thought to that?
Yes, so there are several agencies or individuals that may be in a position to file a petition on behalf of Jason. But based on what we know of both Jason and his father, George, it seems that a likely petitioner would be George. George lives in Sacramento, so a different county from where Jason is located. He has knowledge of Jason's behavioral health history. Maybe somewhat limited more recently, but it appears that Jason does connect with him, especially when he has been hospitalized or he's having a particularly hard time. George, like many family members, are concerned that no one else might file a petition, so he feels compelled that he should file. And George has a very complete history of Jason's early behavioral health history because he experienced it. So those are all observations and experiences that he can share with the court when he files a petition. We would suggest that any family member, as an initial step, might consider seeking guidance from a self-help center or from a local NAMI chapter who can assist with them assessing whether they are in a position to file a petition and what the petition might look like. So once it's established who's going to file the petition, we've talked about the what. We've talked about what the petition should include. We stress that as much information, especially in the narrative portion of the petition, would be helpful for the judge in determining Jason's eligibility. And we talked about some of the support that should be included for that petition. So based on all of that, Deborah, what could George include in his petition when he files one for Jason?
Yeah, good question. Thank you. George certainly, as you mentioned, would have knowledge of his son's first psychotic episode, the one that occurred while he was in college. And Jason's father, George, could document that, what it looked like, when it happened, what the dates were, if there were hospitalizations. He can talk about more recent hospitalizations. He might have knowledge of medication and what kind of treatment interventions were provided while he was hospitalized. And so he should provide as much detailed information that he has. If he's had contact with providers over the years, he could document names, dates, whatever he knows. Because again, we're understanding that it's the judge's discretion to determine if the petition demonstrates that the individual meets or may meet criteria for care. George might think about involving a provider if he has developed a relationship with a provider who has worked with his son over the years. And so these kinds of opportunities may make it a little bit easier to gather the information and to bring it forward. I'm going to switch a little bit to the where. And Leela, we've talked about that Jason was born and raised in Sacramento. His family is there. He hasn't spent as much time there recently. He's been spending time in Fresno. So if George is thinking about moving forward with the petition, what would be some of the considerations?
So I think we discussed this before, so I'll just go through it briefly again, but Jason really appears to prefer Fresno County over Sacramento. George would need to determine whether that is actually Jason's preference, and if so, then Fresno County may be the most appropriate place to file that petition. If he knows where he has been recently treated, if he knows he has connection with a behavioral health provider or peer supporter that has proven successful in one of the two counties, that would be something to consider. Has Jason been housed using a shelter or other housing resources in a particular area so he has some stability? And does he have any family, friends, or other support systems in one of the two counties that would support him through the treatment process and assist him in being successful in the care process? Those are all things that George should consider as he's looking at determining whether to file that petition in either Sacramento County or Fresno County.
Those are great talking points, Leila. And I mentioned this earlier, but I want to say it again as we pause here, that whether or not Jason meets criteria for care, it's really important to recognize that services should continue to be provided, outreach should continue to be offered, engagement efforts should be made, including peer services, including working with outreach workers. And so the care is not the end, it's the beginning of a process, it's part of it. Ongoing services and supports should be made available to the potential respondent. Leila, thank you for joining me. Let's turn it back to Patricia.
Thanks, Deborah, and thank you, Leila. So this is the end of our training on petitioning, thinking through some challenges that have occurred and some problem-solving strategies that counties have been trying. Our goal is that by the end of this session, you will have an increased ability to understand eligibility criteria in the petition process, understand different pathways, and then identify and address practical considerations related to the petition process, including some of that outreach and engagement, those racial and cultural competency considerations, where to file, who should file, and apply those in your county. And if you're either planning now or implementing the care process, you can begin to integrate and pivot and include some of these problem-solving strategies in your county. Just some next steps to highlight for you. We have a few resources on the slide. All of our training materials are included on the CARE Act website. You can include search for petitioning on the training page, and also the resources tab. We've included a few for you, including our training on eligibility, also including some resources for petitioners, and we link out to a few different resources there. And then again, if you're a family member wanting to better understand your role in the care process, or you're a member of the implementation team who's wanting to help family members understand their role, you can also go to that link. To continue receiving notifications and trainings and TA opportunities, please go to our website to complete the link on the form. You can also click in the PDF of this training material. There is no wrong door. So in addition to going to our website, if you can't find what you need or need to identify next steps, please feel free to email us at info@careact.org, and we will try to connect you with the right information. So thank you for viewing this training, and please let us know if you have any additional questions. Thank you.